Hello. In this clip from our Justia webinar, Sarah Frug and Craig Newton, co-directors of the Legal Information Institute at Cornell Law School, will give us an overview of the Legal Information Institute and will walk us through the process of getting law into legal research platforms. Remember, if you want to see more Justia videos on law practice and legal marketing, be sure to subscribe to our channel.
While you've probably never heard of either Sarah or me before today, it's likely you've used our website at law.cornell.edu, which came about more than 30 years ago at the dawn of the internet era with a mission to demonstrate a strong public demand for legal materials that were then found almost exclusively in books inside law libraries. To satisfy that demand with technology that would free the information from those books in those libraries, and to test the theory that both the bar and the public would come to accept high-quality digital representations of what was in those books. While that may sound like a foregone conclusion to our younger audience members today, those of you who are old enough to remember the world as it was in 1992 may well agree that none of those things were certain when our predecessors began this project by mailing compact discs to subscribers before transitioning to BBS and then listservs, Gopher, and ultimately the World Wide Web, where legend has it that ours was the 41st website and the first one not about either theoretical physics or model trains. The free law movement, at least as it exists since the dawn of the internet, is based first on the idea that the public owns the law and has an undeniable right to know its contents, especially where we are all bound by the presumption of knowledge of the law and live under the admonition that ignorance of the law is no excuse. From the outset, LII has been about demonstrating both an unmet need in the world for reliable legal information and technical solutions to meet that need without cost to the public. Today, the website welcomes tens of millions of visitors each year and features a broad array of both primary legal resources and original content. This presentation today focuses on the primary sources and mostly the U.S. Code, the Code of Federal Regulations, and our newest collection, the regulations of all 50 states. And the reason we're talking about those is because most people, including most lawyers, have no idea how complex the process is by which governmental entities, be it the legislature or regulatory agency on either the federal or state level, first create and then communicate official changes to those large bodies of work. So even if infinite monkeys at infinite typewriters for an infinite amount of time would eventually recreate the entirety of the U.S. Code, for example, that is a dynamic body of statutes which changes regularly. In other words, it's one thing to make a reliable copy of something as large as the U.S. Code or the CFR or the regulations of all 50 states, and it's something else entirely to keep that copy current. And so that's a process largely driven by technology. It's all about proper markup and code structure and many, many other things that were not covered either in law school or the Schoolhouse Rock, how a bill becomes a law. But we think professionals like you should be aware of, because if you have some rudimentary insights about what's going on behind the scenes while you're perusing a legal research database, you'll be better positioned either to feel confident that what you're looking at online is accurate or to detect that something might be a little off and maybe you should take a closer look. And by the way, this is true not only for free law resources like LII or Justia. Your paid research platform of choice, whether it's Westlaw or LexisNexis or Fastcase or whatever, employs a small army of technologists to make sure that what you're seeing is current, accurate, and comprehensive. In other words, the process of putting legal materials online looks less like this and more like this. So here's what we hope you'll take away from this webinar. First, Sarah will explain in detail how a big corpus of law like the U.S. Code or the CFR gets online and how it gets updated to keep current. She'll focus particularly on ways in which that process can break down and yield results that reduce the effectiveness of the end product and its utility to you when you're doing legal research. She will explain how the challenges are different when you move out of just federal materials and down the jurisdictional stack, so to speak, into state or local materials online. Then I'll be back to talk about recent and ongoing litigation and what it has to say about how copyright can and cannot limit the dissemination of primary legal materials and adjacent materials necessary to understand and interpret them. We'll talk about case law governing the government edicts doctrine, incorporation by reference, and whether there's a role for antitrust law to have a say in how legal information is created and distributed by the giants in the legal information industry. So now I'll turn the presentation over to my colleague and co-director, Sarah.
Thank you, Craig. My perspective here is that of a legal information publisher, taking free and open primary and secondary data and turning it into legal information systems that support the development of knowledge. Legal information service providers work across large numbers of corpora and knowledge bases, standardizing content, detecting features, extracting metadata, mapping and integrating information, and presenting it all in a way that makes it more understandable. I should say that at LII, much of the applied research focus devoted to what we call statutes and regulations is probably more accurately characterized as enhancing publications of the US Code, CFR, and now state regulations. To give you a sense of what this entails, we can begin by inventorying a basic set of features that LII pioneered as the first online law publisher, and subsequently extended over the course of more than 30 years of publishing legal information for the public. Each of the features noted responds to an information need that users encounter on the web, whether navigating to a legal text from a table of contents, browsing from a list of topics, or far more commonly arriving at a particular section of a legal text via an external search engine with very little context as to what's there. Page headings and indentation clarify the structure of a section. Hierarchical navigation situates the page at hand within its containing corpus. Lateral navigation facilitates traversal from section to section, and citation and reference markup supports rapid resolution of cross-references within sections, a corpus, or between corpora. Entity resolution, for example, of named acts, and definitions clarify the context of the language being used, signaling a reader, for instance, when a term in one section has already been defined elsewhere. Other features require extraction and amalgamation of metadata from multiple corpora, such as cross-corpus citations, and other external resources, including indexing vocabularies, directories, specialized knowledge bases like AGRIS and AgriVoc for agricultural information, or the private letter rulings of the IRS providing guidance for the tax code. Yet other features rely on the combination of the kind of original explanatory content that Craig mentioned earlier and machine-driven annotation to clarify text that seems to fly in the face of common sense. More about that in a moment. So how do we get there? We are making steady progress toward a data environment that maximizes comprehensiveness, timeliness, standardization, cross-referencing, taxonomies, and explanations. Here, it's helpful to quote from Principal Analyst and Director of the Systems Analysis and Quality Assurance Team for the Office of the Clerk in the U.S. House of Representatives, who frequently notes the following aspirations for government data. In her words, government data should be accessible, accurate, complete, described, free, machine readable, permanent, searchable, timely, and usable. It's a tall order, but combined with the work of the Government Publishing Office to earn and maintain ISO 16363 Trustworthy Digital Repository certification for govinfo.gov, it means that the federal government at least has the infrastructure to host a comprehensive, authoritative collection, at least of federal law. But in order to understand where we are now, it's worthwhile to revisit where this all comes from. Legal information services, source data included, still bear some relationship to print. Whether deeply print enmeshed, as with the annual online publications of the CFR finding aids in the packet, or heavily data-centric, as with ecfr.gov, the print mindset persists. And we are still adapting from original print publishing processes and conventions. Not all content is included in publication. Not all included content is represented in machine-readable format. Not all machine-readable formats are fully featured when they're published. When you look back to the mindset of print, a lot of this makes a bit more sense. In print, space is expensive, so formatting might be altered in the interest of being more economical, and incorporation by reference is all the more tempting. More about that later. In print, updates take a long time to be incorporated into the main text, so readers are already accustomed to looking in many different places for a single piece of information. In print, it takes a long time to find things. Marginal notes might be useful, or one might assume that a separate book is open on the reader's desk next to the book containing the primary law text. A favorite example, and one which should be a trivially easy question to answer using the general and permanent laws of the United States. How many stars are there on the United States flag? For USC Section 1, entitled Flag, Stripes and Stars on, sounds promising, but it says there are 48. The rule is stated in the following section, titled with the less search engine optimization friendly same additional stars. And the 1959 executive order referring to the rule in Section 2 is in the notes to Section 1. So it's there, minus the instant gratification we've come to expect from modern information services. More challenging is the content that's not included in the publication at all. Craig will go into this in more detail, but briefly, the practice of incorporation by reference, which is explained in the Office of the Federal Register's Incorporation by Reference Handbook in the packet, makes content, whether belonging elsewhere in the same corpus, elsewhere in another government corpus, or elsewhere in an entirely independent corpus, part of a regulation by referring to it rather than by making a copy. The benefit, particularly in the era of print, is that only one copy of the content is maintained by the entity responsible for maintaining it. The disadvantage, particularly important for applied researchers who are trying to analyze entire corpora, arises when the content incorporated by reference is not reusable or available or accessible. 145 Swiss francs might not sound like all that much, but stay tuned. An even more difficult scenario arises when the content of a corpus is made inaccurate because external events have affected the applicability of the content without altering the content directly. This can happen when the Supreme Court finds a statutory provision to be unconstitutional, a court enjoins enforcement of a law, or an agency temporarily suspends enforcement of a regulation. A great deal of data from a plethora of sources must be gathered, synthesized, and matched to the underlying text in order for legal information services to tip off their users that what they're reading might not be in effect. More quotidian challenges include gaps caused by intermittent interposition of images into textual corpora, including images of text. The Office of the Federal Register's document drafting handbook in the packet makes provisions for figures, forms, tables, notes, and appendices, all of which can diverge from data standards otherwise in use. This slide shows the presentation of a data table in the very richly featured Electronic Code of Federal Regulations website. Not only is the text trapped as a series of pictures, it has a different orientation in the headings than in the rows to conserve space on the page. There is, of course, no horizontal scroll in print. So legal information publishers like LII have our work cut out for us. We remediate issues in the source data that threaten web accessibility for readers with disabilities. We improve usability by filling in missing pieces to provide a standardized user experience across many corpora. We build crosswalks to break down silos between corpora across branches of government and down the jurisdictional ladder from federal to state materials. We even do what we can to incorporate external information to make sure that what the text of the law means reflects the state of the law as it stands right now. But I still haven't explained how we get from lawmaking and rulemaking to legal information services. And reminder that we are primarily focused on enhancing the US Code and CFR. Now, I won't trouble you with Schoolhouse Rock or the details of legislative process. How our laws are made by the parliamentarian of the US House of Representatives is the gold standard regarding any details, and you can see that in the packet. What I will note is the emphasis on the foundations of the government's obligations to disseminate the law, and a couple of caveats. Here I'll quote, "One of the important steps in the enactment of a valid law is the requirement that it shall be made known to the people who are to be bound by it. There would be no justice if the state were to hold its people responsible for their conduct before it made known to them the unlawfulness of such behavior. In practice, our laws are published immediately upon their enactment so that the public will be aware of them. And every public and private law passed by Congress is published in the United States statutes at large, prepared and published by the Office of the Federal Register, National Archives and Records Administration, and made available via the Government Publishing Office's website, govinfo.gov. When a law is enacted, the House Office of the Law Revision Council classifies its provisions to their respective destinations in the U.S. Code, and subsequently they incorporate updates into the text of the U.S. Code. Now, the legislative drafters, the House Office of Legislative Counsel, explain several caveats, and I quote, "It is helpful to keep in mind several other points when using the U.S. Code. First, the code has a different structure than the slip laws and is not a verbatim replication of them. Section numbers and cross-references will usually differ. There could even be some differences in language, although no substantive changes are intended. Second, the process of classifying a slip law to the code often involves splitting it up and placing different provisions of it in different parts of the code. Finally, unlike the slip laws and statutes at large, the code is updated to reflect amendment by later statute. I'll use the example of the National Technology Transfer and Advancement Act of 1995 included in the packet. You'll notice two different types of amending language here. In Section 7, the amendment to the Bayh-Dole Act is made as an amendment to 35 U.S.C. Section 210E, By contrast, in Section 8, the amendments to the National Institute of Standards and Technology Act are made as amendments to the Act. The difference is meaningful. Title 35 has been enacted as positive law, so the text of the U.S. Code is legal evidence of the law. Title 15, by contrast, has not been enacted as positive law, so changes must be made to the statute, and the compilation into the U.S. Code serves only as prima facie evidence of the law. For reference, on its website, the Office of the Law Revision Council notes positive law titles with an asterisk. But this creates a misalignment. The National Institute of Standards and Technology Act originated as a statute over 100 years ago. In the table of popular names of legislation, there is a listing for the former name of the act, Bureau of Standards Act, and then it refers, see National Institute of Standards and Technology Act. Because it has not been enacted into positive law, there is not exactly an official publication of the current version of the act. Imagine collaborating with colleagues on a brief you've drafted, and what you're asked to review is not a red line, but just a series of documents containing successive sets of instructions for where and what changes to make. Of course, it's not quite as bad as all that. The House Office of Legislative Counsel maintains statute compilations. This is an excerpt from the NIST Act as amended through Public Law 117-286, included in the packet. These are not official, but for statutes that have not been enacted as positive law, they are the closest thing we have to a standardized version of acts of Congress published by the government. Close enough? Most legal information publishers and consumers we've spoken to over the years don't seem too concerned.
We hope you enjoyed this video, and if you did enjoy it, please hit the like button and subscribe to our channel for more law practice and legal marketing videos. See you in our next clip.